Welcome and thank you for joining part 3 of Seyfarth's webinar series, Jury Trials in 2024, Seyfarth's Employment Trial Team on Lessons from the Front Lines. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Barry Miller. Barry, you may begin.
Thank you, Brooke, and thanks to all of you in the audience for joining us for this third of our four-part series on jury trials in 2024. I'm breaking my own no ties except for funerals rule today because we're here to talk about preparing for the worst in the course of trying a case. And our objective is to hit the high points on how you go about trying a case to win while at the same time preparing for an appeal in the event that you get an adverse ruling. My name's Barry Miller. I'm a partner in the Boston office of Seyfarth Shaw, and I've tried jury cases from the Southern District of Texas to upstate New York. The reason that I mention that is that this is a very general presentation. I'm joined by Christina Duslak and Chris Kelleher, both of whom are also based in Boston, but both of whom also work on cases across the country. And one overarching theme to keep in mind is that the rules of appellate procedure and what you may need to do in the trial court to preserve your rights do vary from jurisdiction to jurisdiction. And it's important to consult those every time before you start a trial so that you don't get tripped up on procedural technicalities when you're trying to preserve your rights. So what we're doing is not jurisdiction specific. It's intended to focus you on a mindset that you can bring to a trial that allows you to keep in mind the points at which you may need to specifically preserve your rights, and also highlights some danger areas where things can come flying by you in the course of a fast-paced trial. And the way that we've laid this out, which we can talk about on the next slide, is framed around several points during the course of a trial where you want to stop and think about whether there are objections you need to preserve and appellate issues that you may need to make a record on. First, we'll talk about, in very general terms, what preservation versus waiver means in the appellate context. And then we've got essentially a process map of a trial. And we've arranged it in terms of those check-in points that I mentioned, where folks can perhaps even use that as a map during the trial to just pause for a second at key points and make sure that all appellate issues have been preserved. And then we'll talk about a few examples of when and why people waive arguments that are then lost upon appeal, and provide some sort of traps for the unwary and experience from in the trenches that may help keep in mind the sorts of things that one needs to be focused on as a trial unfolds. So we can skip to the next slide. And even one more slide than that. So at trial, winning is always job one. And in many cases, particularly complex cases where you have a large number of witnesses, lots of documents flying, you may have video evidence, that sort of thing, a trial lawyer is going to be naturally focused on presenting evidence in an efficient, smooth, hopefully elegant way that resounds with the jury. And for the most part, you don't want to say anything else. You don't want to interpose legal mumbo jumbo that the jury doesn't want to hear. And you don't want to slow down the trial or be perceived as slowing down the trial. You want to focus on your best arguments and pressing them as hard as you can. But you need to recognize that there are other things that you need to attend to along the way. It really is a striking of a balance in terms of deciding both when and how, and even whether, to make a specific objection and preserve an appellate issue without interfering with the orderly progress of the trial. And it's very much art more than science. It's something that each person sort of has to get a feel for in terms of their own style as a trial lawyer. And there are no right answers in terms of exactly when and how to preserve an issue, but there are very clearly wrong answers. And there are answers that feel very wrong when you're up on appeal and the opposing party is taking the position that you've waived a critically important argument. So that's how we think about it, is putting yourself in a position of avoiding danger rather than trying to specifically and positively compile an appellate record in the course of building out a trial presentation. And we talk in this webinar quite a bit about an appellate preservation plan. You'll see that term referenced a number of times today. And at least in my practice, an appellate preservation plan is really a component of a larger plan. It's a component of a trial plan. And going into any trial, what you should have, and not just in some abstract way in your head, but reduced to writing and circulated among the trial team and the client to make sure that you have everybody's best thoughts on it, is a trial plan that includes the themes of your case, what you are trying to get to resonate with the jury, what you need to put into evidence to get those issues to resonate with the jury, and what you need to prevent your opposition from getting in front of the jury in order to avoid having your themes undermined, disrupted, or blown up in your face. And if you think about a case in terms of your trial themes and why you are entitled to win, that may help you in terms of identifying issues that could be critically important on appeal, to make sure that there's nothing in the core of your trial plan that is being threatened by whatever your opposition is doing. And that can help you make a decision about whether and when to tender an objection, as opposed to potentially letting something go, recognizing that it's not material. So we can skip to the next slide, and even one more after that. This is the sort of map I mentioned in the introduction that follows the basic events in any trial and flags some points where you want to pause and think about whether you need to make a further objection or a record, that sort of thing. And the first time to start thinking about whether there are objections you need to tender is voir dire, or as they say in Texas, voir dire. And you need to present a few questions, if the court's procedural rules allow for this, that are intended to sniff out bias. And there will be a couple of critical questions in the context of a larger list of questions that you may propose to the court be asked of the venere. And the purpose of those voir dire questions, contrary to what you may see on TV, is not to build a great jury for yourself. That's a nearly impossible task. The purpose of those questions is to eliminate jurors who may have a bias. And bias is not an offer-on switch. It's really a spectrum. And there may be bias that would constitute grounds for invalidating a jury verdict. There are more neutral forms of bias, if that's a concept, that may not rise to that level. But your objective in it as a trial lawyer is to get out anybody who has a material bias against you. And so in your list of voir dire questions, it makes sense to have a couple of targeted questions that go to the nature of your client as an entity and whether jurors have a bias against that person, that entity, and anything that may bias them in favor of the plaintiff if you're trying the case on behalf of an employer. And if and when a judge tells you you're not allowed to ask those questions or declines to incorporate them in the voir dire that the judge asks, you may need to make a record of that. If the judge has stricken a question that is critical to identifying potential bias and not allowed you to explore that with a potential juror, you need to object and you need to make a record of that, even though it may be disruptive to the more general process of impaneling a juror. The flip side of that is you also need to watch what your opposition is doing. If your opposition is exercising peremptory challenges, for example, in a way that reflects a bias that may be relevant to the fundamental issues before the trial court, you need to object to that as well. For example, in discrimination cases, there's a concept called a Batson challenge, which is actually borrowed from criminal law. But the idea is that it's impermissible to strike jurors based on protected classifications like race, national origin, and religion. And if you're sitting there and paneling a jury and you see that your opposing counsel is picking off people based on any of those protected classifications in a way that appears calculated or otherwise likely to impact your client in a negative way, you need to preserve that during the jury impanelment process, or it may be lost to you. A second time on the first day of trial to think about whether you need to tender further objections is in the context of motions in limine. And judges vary widely in their practices with respect to motions in limine. Sometimes you'll just get oral rulings the morning of trial. Sometimes they'll be briefed out and decided in writing reasonably well in advance of trial. Sometimes you'll submit them and the judge just won't rule on them prior to trial. And in any of those scenarios, you need to be prepared to make appropriate objections and preserve a record, particularly if you file a motion in limine that the judge does not address. You need to make a record of that and be prepared to continue to object on that issue later in the trial so that it's not lost to you. And because of the informality that sometimes attaches to the motion in limine process, most especially on the eve of trial, it may be necessary to seek clarification of the judge's rulings, including how they apply. So, for example, if you win a motion in limine excluding a certain document or a certain type of evidence, you may ask the judge to clarify that opposing counsel is not allowed to mention that in his or her opening because it's been excluded. That, of course, is one of those things that once something comes out of opposing counsel's mouth, it can be very difficult to unring that bell. And so, in addition to making the best arguments you can in your motions in limine, you need to ground those in the actual trial of the case and bring them to bear if and when opposing counsel starts straying from any orders that the court may have entered. And with that, I think I can turn it over to Chris to talk about our next set of decision points.
Thanks, Barry. So the next key moment to preserve objections at trial is after the plaintiff rests. So you've had your opening statements, plaintiff has put on its facts and witnesses and put in its evidence, and the plaintiff has rested its case. Rule 50 of the Civil Rules of Procedure states that if a party has been fully heard on an issue during a jury trial and the court finds that a reasonable jury would not have legally sufficient evidentiary basis to find for that party, the court may grant a motion for judgment as a matter of law against that party on a claim or a defense. So the vehicle for accomplishing this as defense lawyers is a motion for judgment as a matter of law, which is also called a motion for directed verdict. So after plaintiff rests, defense counsel need to be ready to move for a directed verdict. And ideally, you'd have this either somebody assigned to it during trial or have the motion for directed verdict ready essentially before trial starts. Having it in motion is preferable for a lot of reasons, but you're less likely to waive critical issues if you have a carefully written motion as opposed to doing so on an ad hoc verbal basis. If for some reason you need to make the motion for directed verdict verbally, it's important to have an outline and citations to the law and record. It can be useful to use the jury instructions in charge form, or at least the expected jury instructions and verdict form, to argue to the judge which elements of the case plaintiff has failed to prove. And you need to make sure that the motion is filed on the docket and on the record. A theme for today will be, ensuring as you're preserving issues for appeal, that whatever objection you're making, whatever argument you're making, needs to be on the record for later. You need to ask the court for a ruling on the record, and if the court goes against you after having filed this motion, you should object on the record. Next slide, please. After defendant rests, So you should renew the motion for directed verdict after the defendant rests. This is the next key moment to preserve objections at trial. And you need to insist on putting the motion on the record, which means that if a court reporter or stenographer isn't there, you should ask for one. And depending, certain, especially in state court, it might be tough to do this, but you really need to insist. And when you're renewing the motion for directed verdict after the defense case in chief, you've got all the evidence, the favorable evidence that has come out through documents and witnesses over the course of the defendant's case. So you should incorporate that evidence into the motion and sort of layer it back in for the judge's benefit. And it's important, obviously, to cite specific testimony and exhibits and ask for an on-the-record ruling. Next slide, please. So the charge conference is a really key moment in trial, and the charge conference is essentially a meeting between the judge and the attorneys to develop the jury charge, which is a set of instructions that the judge will give to the jury before the jury deliberates and ultimately decides on the outcome of the case. So the charge conference is a critical time for preserving objections for appeal. At the charge conference, defense counsel must preserve all arguments as to the jury instructions and the verdict form, which I mentioned a moment ago. So you should make sure that the entire conference is on the record, meaning, ask for a court reporter if one isn't there. And it's best to offer proposed instructions before trial, proposed instructions in a verdict form before trial, and also, ideally, you would offer written objections to opposing counsel's charge and verdict form before trial as well. And you can update those objections as the evidence comes in throughout trial. But importantly, defense counsel need to make sure that every single objection is preserved on the record and ideally in writing. Review the proposed charge and form line by line, have citations to authority ready, and be ready to argue to the judge why you object to a proposed charge or verdict form, on what grounds, meaning with having authority ready, and why it matters. And attorneys need to be conscious of making a clean record. Oftentimes, when a written transcript comes out after a trial, you're going through it, and it doesn't seem to make. It might seem to make sense when you're actually there before the judge and arguing things out with opposing counsel, but it doesn't make as much sense in written format later on. So it's really important to make a clean record. If you're speaking to the judge, you can say something along the lines of, Your Honor, on page 6, lines 2 and 3, we object to the definition of pretext. Specifically, the second sentence should be stricken because it is an incorrect and prejudicial statement of law and should be replaced with this language, at which point you would quote this precise language that you want. It's really important to be clear because on appeal, it doesn't always appear as clearly as it did during the charge conference. So for that reason, be paranoid, be extra careful about the possibility of waiving objections, particularly during these key moments at trial. The jury instructions and verdict form are fertile grounds where errors can pop up, and the charge conference is sort of the critical junction for preserving objections on appeal. The jury instructions and verdict form are the foundation that the jury will use to analyze the evidence and the arguments and ultimately make their decision. So it's really a critical time, and you really want to make sure you have a nice, clean record and make sure that the charge conference is transcribed or otherwise recorded very clearly. So, make sure that every objection is preserved. That can be tricky where the court or opposing counsel propose alternative or additional instructions in an attempt to cure the objection. In many cases, the judge will put pressure on the parties to either, simply agree to an instruction or move things along. But it's really important as defense counsel to not just blindly agree to those instructions. either by remaining silent or by express agreement, unless you're absolutely sure that the alternative additional instructions cure your objection. So, if you don't stand by your objection to a particular jury instruction or verdict form, you risk waiving that objection. So, it might be uncomfortable, but it's really important to stand your ground, even if it risks irritating the judge. So written objections are best practice. As verbal objections can be difficult to make on the record, but even a general oral objection is better than nothing. And as discussed, be as detailed as possible in your objections, meaning clearly state what you're objecting to, the grounds for the objection, and having authority if possible is the best practice. Next slide. So before the jury charge is actually read, you might have additional time to preserve objections. Unfortunately, going through the charge conference doesn't mean you can let your guard down necessarily. If possible, before concluding the charge conference, you should request or even insist that the judge commit to writing the precise words he or she is going to read to the jury so that you can have an additional opportunity to reassert or raise new objections. Most of the time, the court will provide parties with a written copy of the instructions and verdict forms that it intends to read to the jury, but that doesn't always happen. So if the judge, does provide written copies, you should use whatever time you have before the judge reads them to the jury, which probably won't be a lot of time, to at least review them and renew any objections that you made at the charge conference or raise any objections that you didn't previously raise. So there might be some time there. So at a minimum, counsel should renew objections to the court's refusal to give an instruction, including any clarifying or limiting instructions. And counsel should also make objections to any proposed instructions being given that counsel opposes. Like I said, the judge might be impatient and you just went through the charge conference, so might push back on you, but it's important to make a record on this stuff. If the judge does not provide a written copy of the instructions or verdict form, then it's really important to listen carefully to the charge as it's read to the jury so that you can renew any objections or make any additional objections after the court reads the charge. And in fact, it's best practice to do this anyway, even if the judge does provide written forms. So that brings us to the next slide, which I believe Christina will handle.
Great, thanks, Chris. So again, we are now after the jury charge, and this is the last chance before the jury begins its deliberations to address any issues or errors with the instructions or verdict form. So as Chris just mentioned, you really have to listen closely when these are read to the jury. Certainly, if after hearing the charge read to the jury, you identify an error in the instruction that has not been previously raised, then it's important to ask the court for a sidebar and object. Again, when you're hearing that jury charge read, it could also help you identify additional errors and just, it could also lend further support for any prior objections. So for example, we tend naturally to focus on determinative instructions. So that is instruction setting forth the elements of a claim or clarifying the criteria for those elements. And that can be sometimes at the expense of other more routine instructions, like instructions on the applicable evidentiary burden. Hearing these instructions read out loud may help identify missing, conflicting, or confusing instructions. So for example, you may find that a generic evidentiary burden instruction doesn't accurately convey plaintiff's burden with respect to an issue or a cause of action. You can also find that because of changes to other instructions, an instruction summarizing the case now conflicts with more detailed instructions or assumes the answer to an issue of fact that takes an issue away from the jury. So regardless, if there is an error in the instructions or the verdict forms and you have not already preserved it, you should ask the court for a sidebar and object. And if necessary, you should request a clarifying or supplemental instruction if it's appropriate. All right, next slide. So, in the event of an adverse verdict, it's important to keep focused on preserving objections. Before the jury is dismissed, however, you want to make sure you review the verdict carefully, you raise any inconsistency in the verdict with the court at sidebar, and in many jurisdictions, an objection to an inconsistent verdict is waived if it's not immediately raised when the jury can still be sent back. The other thing you should consider is asking the court to poll the jury to ensure the verdict meets the requirement for an adverse verdict in your jurisdiction. So as a general matter, that means polling the jury and asking each juror individually whether he or she agrees with the verdict. So for example, say in California, there's 12 jurors, 9 of which must agree to the verdict. If upon polling, more than 4 jurors disagree with the verdict, the jury has to be sent back for further deliberations. Finally, you want to put on the record that you intend to move for judgment as a matter of law in a new trial. And if necessary, ask for a briefing schedule. You're going to see in some jurisdictions, this schedule is actually statutorily prescribed. Again, if we haven't made clear, and this is a key thing here, preserving an issue for appeal, it can be uncomfortable and there are risks with irritating the judge, but preserving the record is just part of the job of trial counsel, and it's important to have a clear record of your objections for appeal and the court's ruling on those objections. So you never want to assume an issue is preserved as a matter of law, because it almost certainly isn't in a lot of cases. And so we always assume that it's up to you to preserve the necessary objections. And so with that in mind, we're going to turn to some waiver pitfalls to look out for. So we're going to go to the next slide, and actually the slide after that. All right, so our first pitfall is not completely objecting. We the sort of kind of objection. The key thing is an objection has to have 3 components: a clear statement of the objection on the record, and you need to state the grounds. So with the court reporter present, you're saying objection, hearsay. You want to know in advance your jurisdiction's rule for how much specificity is required. Is it just an objection? Do you need a rule number? We want to, sometimes we say it's helpful to have a list of possible objections. You want to make sure that the court reporter is there. And, it sounds basic, but, they're not always there. There could be times when, before the court reporter, arrives, the judge is talking with folks, or before everyone's back from lunch, or if it's a motion session and sometimes there's no reporter, you want to ask for one. And if that's not feasible, restate the objection when you get on the record. The other important thing to remember is to stand up for objections, both out of respect for the court and to keep a clear process. Next slide. Another pitfall is accidentally agreeing to a bad jury charge or a verdict form. So then if you get a bad verdict, you won't have that bad charge or form available as an argument for appeal. So for example, we've seen cases where the lawyer objects to the way a claim is phrased in the charge, but not in the corresponding question on the verdict form. You need to do both. We also have seen cases where the lawyer objects to the judge's first proposed charge, but then the judge passes out a revised proposed charge the next day, and the lawyer doesn't repeat the objection. So now things are ambiguous. You want to think of your record like an appellate lawyer is going to see it. So let's say the plaintiff wants an instruction and question on whether your client spoliated evidence. You object. If you get a bad verdict, you want to be able to argue that the spoliation issue was a reversible error. And the appellate lawyer will want to see in the transcript a through line where you objected to each and every time it came up. So in motions in limine, with witnesses and exhibits, in the charge conference, all forms of the charge and the verdict. And that's what it's going to take to set up a successful appeal. Next slide. Another pitfall we see is setting up and forgetting a standing objection. You know, it's tempting to rely on a standing objection when you have the same recurrent objection to a line of questioning or a document. It's critical to research the rule in your jurisdiction as to whether a standing objection made on question 1 is enough to preserve that objection on question 8. And so if you do ask for a standing objection, get a clear ruling on the parameters. So for example, Your Honor, I want to clarify that my standing objection to hearsay will pertain to all questions regarding plaintiff's proposed Exhibit H. Is that correct? You want to avoid a situation where later reviewing the transcript, as Chris mentioned, this tends to happen. You're reviewing the transcript and nobody can tell whether a particular question was objected to under a standing objection. And in that case, it could end up being waived. You know, especially on really important issues, a best practice is usually to repeat the objection rather than to just rely on the standing objection. All right, next slide. Take it back to Chris.
Thanks, Christina. So continuing the theme of waiver pitfalls, and this sort of also continues the theme of, you know, potentially be irritating the judge, but needing to push forward anyways, being too polite. So, you know, obviously we want the judge and the jury to like us. We want to be polite. We want the jury to be on our side and like our case. But at the same time, the judge wants to keep things moving along. The jury wants to go home and wants the case to be over. So all these dynamics create pressure on trial counsel to just move on rather than, you know, sticking on objections. So these dynamics can make it hard or even, you know, sometimes awkward to make a record. Sometimes attorneys will decide to skip an objection that they could have made because it's not worth the cost. You know, you might look like you're hiding something. You might look like you're worried about something. You don't want to annoy the jury. You don't want to belabor a point. And that can be a fine, and often it's a good decision to skip a minor objection. But I think the takeaway here is when it's an important issue and attorneys need to preserve the issue for appeal, you really need to stand up and make it clear that you're objecting and preserving your record for appeal. And you can ask for a sidebar if needed, as Christina mentioned. When the judge is pushing everyone to move on, you know, judges understand that you need to make a record for appeal. So you can tell the judge that. They understand, and, you know, it's their job, and they'll ultimately allow it even if they're irritated or want things to move on. Next slide, please. So another waiver pitfall is letting bad evidence linger before the jury. Obviously, sometimes opposing counsel may improperly introduce evidence that can hurt your case. And the evidence could be prejudicial, irrelevant, otherwise improper for whatever reason. But it's now, you know, the jury has it, and how are you going to unring that bell, essentially? So unless the jury is specifically instructed to disregard the evidence by the judge, or that the evidence cannot be the basis for their determinations, the jury is free to consider the improper evidence that it has heard. And in that case, any appellate claim that the bad evidence influenced or misled the jury could be lost. So needless to say, it's a mistake to let bad evidence linger before the jury. Attorneys have to be, you know, on their game and ready to act. And depending on the evidence, may want to either move to strike or request a curative instruction. And if the evidence is really bad, you may even consider moving for a mistrial. So, you know, it's important to keep these points in mind. And if the court refuses your objection, you know, objects their refusal and makes sure everything is on the record. And certainly, talked about the charge conference a minute ago. This is something that you should re-raise at the charge conference by requesting a curative instruction or a limiting instruction, or even requesting a mistrial if the circumstances call for it. Next slide, please.
It's back to me, Chris.
Yeah.
This is the second to last pitfall that has sort of resonated throughout this presentation, the importance of making sure that not only you make a good argument, but that that argument is available and clear to the appellate court because it's on the record. And judges vary widely in their practices with respect to keeping a record during trial. At one end of the spectrum, I was once trying a case with Judge Lee Rosenthal in Houston, and I was just going to ask her what time she thought we might break for lunch, and she stopped me mid-sentence. She said, "Counsel, in my courtroom, everything's on the record, including when we go to lunch." That's an exception. Most judges don't do that. And in some jurisdictions, for example, in a lot of state court jurisdictions, you may not have a court reporter. You may be relying on some sort of a digital transcription system or another means of electronically recording a trial to potentially be transcribed later, which can make it extremely difficult to know when you're on the record and not. It can also make for a very muddy record because those electronic mechanisms just don't always work that well. And you're not in a position, for example, to ask whether the court reporter got a certain piece of information. And you can't ask the court reporter to repeat anything back. It all just sort of disappears into a void. And for that reason, one thing to think about as you begin to prepare for a trial is whether you want to bring your own hired gun court reporter. That is something that we do in a lot of contexts. Hopefully, it's not something that you often need to do in a jury trial. It comes up frequently, for example, in administrative proceedings, might happen more often with a bench trial. But if you're in a jurisdiction where you may or may not get a live court reporter when you're trying a case, you really should consider bringing your own. And that includes discussions that may be somewhat informal. Again, judges vary in their practices, but some of them will attempt to resolve an issue in chambers, which is typically not going to be on the record unless you as counsel make a point of insisting that it's on the record. If you find yourself in a situation where it's simply not possible to get a court reporter where you need them, where the judge won't allow you to put something on the record in a given context, then what you need to do is put that in your pocket, and as soon as you are back on the record, make a point of making a record on that issue. Even if it's already been decided, you may need to recite what that decision was so that it's quite clear and available to you on appeal later and hasn't just disappeared into the void. If something extreme happens, where you're just not in a position to get the court reporter to take down whatever your position is, an objection or other preservation of an argument, another thing that you may consider doing is having a brief prepared, something very succinct along the lines of a motion in limine, but to be submitted during trial. For example, if any of you have ever had the joy of trying a case in the Alexandria Division of the Eastern District of Virginia, which many people affectionately refer to as a rocket docket, you may not have enough breath in your body to get an objection out quickly enough to keep the trial from passing you by. And I had a case before Judge Caceres down there a number of years ago where it was very much that phenomenon. It was just moving at an incredibly accelerated pace. And we knew that there were certain evidentiary issues that were important. And so we had prepared a brief on that subject. And when it came up at trial, we tendered our objections, which the judge would have preferred to just move through. But we insisted on handing up a written form of this objection, which actually turned the ruling on that issue and preserved an important appellate point for us, which might have otherwise been lost. So you really do need to think creatively and bring every tool in the kit to bear to make sure that one way or another, your arguments are making it into the record with sufficient clarity and sufficient support to be available to you later. Next slide. Yeah, there we go. This is a point that Chris covered earlier in terms of how directed verdict motions work, a Rule 50 motion. And one thing that I would emphasize is that you really should have that motion pretty well drafted before you even make opening statements, because in a lot of ways, that Rule 50 motion is your trial plan. It is a written down statement supported by cases that lay out your position as you hope it would unfold. And those of us who have done this a few times know that no plan survives contact with the enemy, as they say. And so you need to make sure that your directed verdict motion evolves over the course of the trial. And so one thing that I've done in a number of complex cases is bring a lawyer, including a senior lawyer, to sit there and do nothing but make sure that the directed verdict motion is ready to go when the time comes, when the plaintiff rests or when we ultimately rest. And in some jurisdictions, you may be able to get daily transcripts of the proceedings and actually have a fully cited brief that's up and ready to go. You still need to be prepared to argue it orally because the judge might or might not read it, but there's really no better way to preserve a set of appellate arguments than with a Rule 50 brief. And it's organized, it's clear, it's supported by whatever support you can find for it. So I really do think of this as the moment in a trial, particularly the first Rule 50 motion that you'll file after the plaintiff rests, where you need to button down and revisit any and all appellate issues that may need to be preserved. And then we can move on to the next slide. This is our final sort of waiver pitfall, and they're all sort of in a theme. But one thing to think about relates to a point that was made earlier about the scope of any rulings that the court may issue on an evidentiary set of topics. The judge may rule either in the context of a motion in limine or later in the trial, just an ordinary objection. The judge may rule in your favor, and you take the points for that, and you consider it a win. And again, you have this tendency to move into a mode where you're not being cantankerous in front of the jury. You're not objecting for the sake of objecting, and you're not trying to hide anything from the jury. But you can't assume that a prior ruling is going to last forever in the course of a trial. And so, for example, if you get a motion in limine ruling in your favor, but opposing counsel continues to either skirt the boundaries of that ruling or just openly defy it, you need to raise those objections again, because there are jurisdictions in which a failure to repeat that objection, even if you've already prevailed on the issue, may be a waiver. So you need to be mindful of that. And that is really all that we have in terms of our waivers or our object lessons and how not to preserve an issue on appeal. What you'll see on the screen now is our CLE information for this presentation. We hope it's been helpful to you, and we hope that you'll join us on September 25th for the fourth and final and potentially most entertaining installation on this webinar series, in which my partners Lynn Kappelman and Don Soloway are going to invite a mystery guest from the plaintiff's bar to talk about trends and things that we're seeing in the trial of employment cases in 2024 in the post-pandemic era. So we hope you have enjoyed this. We hope you'll join us for that, and thank you for joining us.